With the potential lifting of Roe v. Wade, Margaret Atwood's Handmaid's Tale is starting to look like a reality. And if this has you worried, you might want to delete your period tracking app, because if you're a woman living in the United States, there's a good chance that your data is giving your choice away. Welcome back to Technality. I'm Jacqueline Swan, and today I'm looking at how someone's phone could give away the fact that they got an abortion. Now, Roe v. Wade being overturned and abortion banned in some states raises a lot of concerns, but one of the biggest ones being is, could someone's data trail be used as evidence against them to prove they got an abortion? But before you do that, don't forget to subscribe to Technality so you never miss an episode. Your cell phone tracks you everywhere you go, and it could show the where and when a woman goes to get an abortion. Prosecutors can have and will use data in trials, and it's not just the court system that can access this information. You don't need a subpoena to get data. In fact, data brokers will essentially sell it to anyone. For example, Vice's motherboard was able to buy a week's worth of data from 600 Planned Parenthoods for $160. $160. Let them see which clinics people visited and where they went after. So if you start out in Texas and then travel to a clinic in California and then return back to Texas, your location data could give it away that you obtained an abortion. All someone needs to do is buy the location data for Planned Parenthoods in states that allow for abortion and see if the people traveling there are coming from banned states. And while this information is anonymous, it's not hard to put two and two together to figure out who this person is. And if you're in a state like Texas where you can sue someone for having an abortion, having a travel log is valuable evidence. Another piece of data that might be telling on you is your menstrual cycle, specifically the app you use to track it, because you have years of personal data of when you were ovulating and on your period, and that could be used as evidence to show that you terminated a pregnancy, whether it's missed periods or you were tracking that you were pregnant and then returned back to your normal cycle. These are all discrepancies in years of data, and these apps aren't necessarily storing the user's data with the user's best interest in mind. The Flow Period app sold its users' information to companies like Facebook and Google after promising they wouldn't. And they're not alone in doing this. Usually you would assume that this information is protected under HIPAA, the federal law that states that you can't disclose a person's medical information without their consent. But it's not. Companies technically aren't violating your right to medical privacy by selling off this information. Now, there's potential that even a Google search will get you in trouble. Whether you're looking for the closest clinic, ordering abortion pills online, or just seeking information, a simple inquiry could be used to show your intent. And this has already happened. In 2017, Latice Fisher gave birth to a stillborn in her Mississippi home. The baby was pronounced dead, but the question became, did she give birth to a stillborn or living baby? The coroner used an outdated method where they float the baby's lung to see if it was born alive or dead. And when I say outdated, I mean this was developed in the 1600s. And this controversial technique came to the conclusion that the baby was born alive. Now, the prosecution just needed a motive, which came in the form of Fisher's search history. She Googled ways to induce a miscarriage and searched for things like buy misoprostol abortion pill online. Fisher already had 3 kids and she didn't want more, so that's why she did the searches. Paramedics noted that the fetus was about 35 weeks along, which is past the recommended time period to take the pill. So between an archaic technique and modern technology, they were able to indict Fisher on second-degree murder, which carries a 40-year sentence. Ultimately, a grand jury decided not to pursue charges, but her Google search history was still used to build a case against her. So much of our lives are tied to our phone. A woman's search history, period tracker, and location data can lay out a map that she received an abortion, which shouldn't be an issue. But if Roe v. Wade is struck down, women living in stricter states could potentially have this information used against them. Now, if you're looking to access a safe abortion without all of this surveillance, there are a number of citizen groups who have put out information on how to do that, including the Digital Defense Fund and the Electronic Frontier Foundation. Now, the decision to strike down Roe v. Wade hasn't passed yet. Access to a safe abortion is still legal across the United States, even if some states have already started to restrict it. But on the chance it passes, some states are going to prosecute people harsher for seeking an abortion in a place that it's legal. So if you are in a state that is currently restricting the procedure and is most likely to ban it outright if Roe v. Wade is struck down, you you might want to start researching now how to avoid your digital footprint if you need to seek an abortion, because that search history in itself might be used to prove your intention to get an abortion. But what do you think about all this? Should people have access to women's medical data? Like, there are some serious Handmaid's Tale vibes. If this video was useful to you, give it a like, and if you want more content about where your future is going, subscribe to Jacqueline.